Well, let's resume the academic journey with the last lecture of the second workshop. This lecture is entitled The Unequal Type of Law Under Distributive Justice Watch and is given by Professor Diego Papayannis. Professor Papayannis is a lawyer and has a master's degree in law and economics from the University of Buenos Aires and a PhD from the Pompeu Fabra University. He was later a visiting research scholar at Yale Law School. He is currently Serra Hunter Professor, Philosophy of Law, and researcher at the Cátedra de Cultura Jurídica at the University of Lyon. His lines of research focus mainly on the philosophical foundations of private law, causality, the economic analysis of law, and the general theory of law. He is currently developing a new line of research focused on the contribution of private law to the equality of life. Professor Papayannis, thank you very much for your presence.
Thank you. Thank you very much for the presentation. Good morning. Okay. First of all, I want to thank the University Externado de Colombia for hosting this second workshop of the network. And especially, I want to thank Alexander Vargas for all the work he put into the organization of this workshop. I know that he had to overcome several difficulties. It was not easy. So thank you, Alex. In this paper, the question I want to address is whether an equal federal law can be justified or defended within a more general framework of distributive justice. According to what I would call the orthodox view of private law, it can. In fact, distributive justice considerations are to be excluded from the design of private law, and especially in legal adjudication. They have no place in legal adjudication. This is because the law, private law addresses in general interpersonal problems. It is like an expression of the principle of corrective justice or interpersonal justice, and in contrast, distributive justice addresses collective problems. And it is impossible to solve collective justice, general distributive justice, within the limited framework of private law, which has a bilateral structure that is limited to the parties of the interaction. So the question, the why me question will always be on the table. Like, why do I have to contribute just because I was unlucky enough to be in this particular interaction with someone poorer than me? And on the other hand, the why not me question is also relevant. Why me? I should deserve some redistribution, but I was not lucky, for example, enough to get hit by a car owned by a rich man. So these are the limitations of the bilateral structure of private law, that in turn means that the burdens of distributive justice should be held by the whole society and not particular plaintiffs. This is of course, this does not mean that for the supporters of orthodox private law, distributive justice considerations are irrelevant. They think that they're relevant, but that should be handled through public law mechanisms, taxation, public spending, welfare programs, redistributive programs in general. The starting point of orthodox private law is the claim that in the state of nature, we all have a right, an innate right to freedom. Since everyone has this innate right to freedom, then the freedom of everyone has to coexist with the freedom of everyone else. And this means that no one can be constrained by the mere will of others, or the mere desires or the needs of others. This is the idea of normative independence that is implied by the idea that persons are to be conceived as self-determining agents, that is, agents that decide by themselves what goals they want to pursue in their own lives. Now, how can we respect the the other person's rights to freedom in the state of nature. And this is something that always called my attention, that the idea is that the manifestation of freedom, the immediate manifestation of freedom is the right to my own body, because I cannot act not through my own body. And this is translated into some kind of right not to be touched, which is without my consent, which is a very limited right. So as long as I don't touch you with your consent, I do not violate any of your rights, and this is the only right that we all have in the state of nature. As you can see, this state of nature depicts a rather precarious world in which only very simple plans can be undertaken, can take place. For example, Weinberg gives this example: if someone takes an apple from the tree, I cannot grab it from your hand, because if I take it by force from your hand, I will have to move your fingers against your will. So I will violate your right or your physical integrity. But if you leave the apple on the table even for a second, I can take it without violating rights, because I'm not touching you. This conception of the inner right to freedom grants reciprocity. It's true, but I think does not grant significant freedom. And Kantians might think the same, because for them the most rational step is to move towards what Kant calls the civil condition, which is civil society with a legal system including more rights. In the civil condition, new rights such as property rights or the right to contractual performance are introduced, are recognized. And this is like a fantastic technology, because now we can exercise control over external objects, things, without being in physical contact with them. Now, if I own the apple, no one can touch it without my consent, even if it's on that table. And at the same time, since we now have contractual law, contract law, now we can engage with others in more complex and sophisticated plans. This new system of rights should also be directed to securing reciprocal freedom. So whatever the configuration of the new property rights, contractual rights, contract rights, they should respect this idea of reciprocal freedom. Now, the problem with these rights, especially property rights, is that they create the possibility of unlimited accumulation, and therefore they allow the possibility of subordination. That is, for those who are left with nothing to acquire, once everything has been acquired for someone else, the person who didn't acquire, for example, a piece of land, would need the permission of someone else to occupy the space that he's occupying. And this seems to violate clearly the principle of independence, because I will be dependent of another person's goodwill. So the prospect of systematic dependence calls for institutional law, distributive justice. And ultimately, the legitimacy of private rights depend on the fact that independence be restored. And this is done through mechanisms of distributive justice. So distributive justice mechanisms are justified or entering the scene to legitimize a system of private rights, such as property rights. This is in a very briefly explain the core, I think, of this Kantian view that is translating what I call, or is present in what I call orthodox private law. I have three lines of objections of criticism. The first is that the description of the status of nature is implausible. Second, I will argue that institutions of distributive justice alone by themselves cannot guarantee some genuine or true independence. And third, I will explain that orthodox private law assumes a rather limited or narrow view about the domain of distributive justice, and also that it misses to grasp the problematics of poverty in real life. I'll begin with the state of nature. In the state of nature, people are conceived as independent, and this implies that they are inviolable. They cannot be constrained by the right. They only can be constrained by the rights of others, as I said before, not the will, the needs, or the desires of others. So since the only right that there is the right not to be touched without consent, Achilles, for example, could take all the apples in the tree, leading Hector to starvation and ultimately to death without violating Hector's rights. But is this description plausible? This is what I want to argue that is not. Because one thing is to claim that the state of nature is a pre-institutional state of affairs. There are no institution, no legal rights. Another thing is to claim that this is a space free of morality. The supporters of the Orthodox private law do not think this later thing, because they claim that there is at least one innate right, which is a moral right to freedom and right not to be touched. But the question is, why is that the only right that exists in the state of nature? And I think that it's plausible to argue in the following way. Suppose this is the argument I want to make. The fact that Hector will die if Achilles takes all the apples in the tree, combined with the fact that Achilles cannot eat all the apples before they rot, it's a reason for Achilles not to take all the apples in the tree, not to appropriate of everything that is to eat in that situation. Absent other countervailing considerations, this is an undefeated reason. So Achilles will be bound to act on those reasons, because there is no other opposing reason to do anything different. So he should abstain of taking all the apples in the tree. So if this is correct, then Achilles will be doing something wrong if he takes all the apples in the tree, even if he cannot eat them, just to see Hector die, or just for fun. And if it is wrong, it's certainly wrong because of the dire consequences this has on Hector. What else? Now, from there, it seems reasonable to claim that Hector has a right that Nagon determines his death. In the state of nature, Hector has a right that Nagon determines his death for not good reason, just for fun. I think this is a plausible line of argument, and this is consistent with something that I think is also clear, that respectful coexistence requires much more than not touching others without their consent. I would think that Achilles is disrespectful to Hector if he takes all the apples in the tree, even with no benefit for himself, just to be mean to Hector. Now we can push the argument a little further. We accept the previous reasoning and ask whether it is possible to claim that in the state of nature there is a moral right to unlimited appropriation of scarce resources. Scarce resources, not scary, scarce resources. And I think this is hardly the case also in the Kantian vein, because this is not a conduct that can be generalized. Can be converted into a universal maxim, appropriate of everything without leaving anything to the other, leaving everyone else with nothing to acquire. Well, this is not a liberty that everyone can exercise. So if this is correct, then also in the civil condition, rights can be limited when the noble operation is expected to cause antisocial effects. This is the way in which I question the description of the state of nature, and then in the civil condition, I question that property rights should disregard the distributive justice consideration. The second line of objection is that, as I said, that distributive justice alone cannot guarantee true independence. If you remember, reciprocal freedom is inconsistent with interpersonal dependence. So no person should depend on the will of others as a consequence of normative system that allows for unlimited accumulation. And public law redistribution is supposed to solve this problem. However, as Hanno Dagan has argued, once institutions of distributive justice are implemented, this interpersonal dependence does not evaporate, does not disappear. It's turned into a social dependence because the person in need now depends on the state bureaucracy, Dagan says. Weinreb explicitly rejects his arguments. He replies to this in his related book, and the argument is that the state is under an obligation to provide some aid to the poor, which is correlative to a right to receive that assistance when you're poor. And hence, if you have a right against the state, against all of us, then you do not depend on the goodwill of the government or the state or the collective. You have a right. But I think the argument is insufficient because the duty to support the poor is undetermined. It has to be determined. And in which way is determined? It's determined as part of a public policy. The decisions about how much redistribution should there be is decided in the public arena. And this calls the person in either a safe stand or the person calls it to some collective decisions, the result of collective decisions in at least two respects. There are ideological disagreements about how much redistribution should there be. So the person is subject to, in a way, to the whims of politics. And this is something that we can check. Redistributive policies change from government to government. They are unstable. And also, sometimes they are not optimal. They are the result of a compromise between different political forces. So there is a dependency on the collective choice that matter. Whether you will receive an amount of redistribution that is enough for a decent life depends on what happens in the best of the worst in democratic countries. Second, there is a contextual dependency, because the availability of resources define whether you are going to get or not the aid you need. So in sum, it is possible that for ideological or contextual reasons, democratic societies decide to grant insufficient aid, say only the minimal for biological survival. But biological survival is not the same as a decent life that is worth living. So this outcome will be legitimate from the democratic point of view, but I think it would be unacceptable as part of the social contract, because it wouldn't be rational to accept a scheme that allows for interpersonal exploitation or social exclusion, and at the same time does not preclude the possibility of factual dependence on the goodwill of others. A different problem that, in my view, is also very important and significant is that public assistance is as the only systematic response to failures of distributive justice undermines the social basis of self-respect. That, in the Rawlsian theory, is one of the primary goods. And the reason I say that is I rely on some empirical studies and then in common sense. But I found some literature that some empirical studies conducted in the United States about poverty and think, okay, that's so obvious. Yes, because a minimum exercise of empathy will tell you the same that I'm going to explain here, that is that recipients of welfare programs usually suffer from anxiety and shame. They feel like that they have failed in this, what I have called this acquisitive cumulative competition. This is part of our capitalist countries, but is direct consequence of this Kantian view about how the rights should be distributed. This is also the fact that you're a failure. If you need the assistance of the public, it's also perceived, and the people in need know that socially are deemed to be failures. So even if receiving social welfare is a right against the state, as Weinreb says, It is curious that it's a right that no one exercises with pride. Instead, they exercise it in the most concealed way. And here, the example of the food stamps, some tickets to get food, there are some programs in the States, in the United States, is very interesting because people spend those food stamps in another neighborhood. They don't want to be seen buying groceries and being dependent on social welfare. Related to this is the fact that people on welfare suffer severe stigmatization and also interpersonal mistreatment. Most of the interview people reported that they have been mistreated by employees when they show the food stamps. They have been treated different than regular customers. And also other customers mistreated them. They judge, for example, the kind of products they decide to buy. It looks like socially it's completely inadequate if you are on social welfare to buy wine, a bottle of wine. Even if it's to celebrate a special occasion in your family, you're not allowed because you are in social welfare. Additionally, people on welfare feel dependent, has this feeling of dependence in at least three senses. The first is the obvious. They cannot help thinking that they are living at the expense of other people. The second is the bureaucratic dependence. They have to do, because aids are conditional, so they have to do whatever the administration says they have to do at the time that the administration says they have to do it. So they feel that their autonomy is being limited, but the system that provides the only help that they can get is this kind of system that allows for unlimited accumulation. And third, some of them feel trapped by the welfare system. They don't see a future in which they are completely independent. They don't rely and they get a job, they get a normal life. So it's for depressing to be on welfare. It's not like, okay, let's allow private law to do whatever it does, and then we solve it through public law distributive mechanisms. It's not that easy yet. And finally, 90% of the interviewed people thought that most welfare recipients were responsible for their own situation. 90% thought that their fellow recipients were lazy or they made bad choices. But when they were asked about their own situation, they said, no, my case is different because my father died when I was young, I had an accident. They always find some excuse, and I mean excuse in the sense of some reasons that make understandable why we are depending on social welfare. But this is beside the point. The important point is that social stigmatization is so powerful that even affects the people that is being stigmatized in the sense that they share the stereotypes associated with being a recipient of social welfare. Of course, you might think that all this is contingent and that public programs, redistributive programs can be improved to be, for example, more discreet to avoid social stigmatization, and it is true. These are all contingent facts, but they are invariably present in all societies, I know. And second, and most important, is that the roles assigned to public and private law, this institutional distribution of labor, is highly divisive because it tells us that there are active members of society that can support themselves, that can contribute to the common pool, that they add value to society. And on the other hand, the other people that are passive members of society that cannot support themselves and that only take from the common good. And this is something that I think cannot be solved within the welfare program, public law, redistribution programs. Because if you are on welfare, it's a conceptual matter that you take more than you give to society. In a sense, the social contract is not rationally acceptable thing under these conditions, because in the Rawlsian original position, people will do everything to avoid the social circumstances in which the social basis of self-respect are undermined. So they wouldn't accept just private law to wreak havoc because we have public law, distributive justice institution that will solve the problem afterwards. On the other hand, redistributive private law, I think it's much better because it does not generate any of these problems. Redistribution in private law is silent, completely discreet, and is mostly preventive of exploitation and social exclusion. Private law redistribution is not attached to any shame or consequently any anxiety. So the redistributive effects of private law should be taken into account when you design public policy. This is the main thesis I wanted. The last criticism is that the scope of distributive justice as conceived by orthodox private law is too narrow. Remember that redistribution is necessary to legitimize a system of rights that can create and usually creates social exclusion and hence subordination. Arthur Ripstein, in his book on Kantian theory, Force and Freedom, has very good examples. Take two. If illness and medical expenses usually lead citizens to poverty, the state can create a universal health system. And the second example is that if the labor conditions are really dangerous and unhealthy, and some people get terribly injured, well, the state can regulate labor relations to prevent those detrimental effects. I think these are very good examples of distributive justice policy, but I don't think they fit quite well within the Kantian framework. I'm sorry. But what is the problem? With the labor law example, the question is why restrict the autonomy of persons? Why not let them bargain? If you don't want to accept this job, don't take it. No one is forcing you to take it. And you cannot force me to give you a job in different conditions. And then we have distributive justice institutions. If you break your back working for me, don't worry. We will give you some food stamps. That would be, I think, the consequences of the Kantian framework. Of course, say no. But the first example is even worse, I think, because if someone is in a poverty condition because of illness, suppose a child that is born blind, that unfortunate situation is not the consequence of a system of rights that is just unlucky. So how come you impose taxes on other people who did not benefit from that fact that the child was born, to support the child? I think that within the Kantian framework, it's difficult to explain that. And this narrowness, in a sense, is normatively plausible, I think, and also does not fit the practice in our liberal societies, because in our liberal societies, we provide aid, compensation, for example, for victims in terrorism. This is the case of Colombia, also in Spain. And how are victims of terrorism related to the system of property rights? They are not harmed by a system that generates exclusion. So it's not the society's concern what happens to people that are. Actually, it's a fact of corrective justice. There is someone else who is responsible for that. How come distributive justice is pertinent? But I think we all share that is pertinent, that is within the domain of distributive justice. And the same with many other cases. If a hurricane destroys a city, we have the distributive justice duty to provide some aid. But that's completely unrelated to the system of property rights that elicits institution of distributive justice. The possibility of subordination created by the system of property rights is the only certification for distributive justice. So all these other cases that I think we will share that are part of distributive justice should not be part of distributive justice according to the Kantian framework. Let me conclude by saying something about why private law is so important in fighting poverty and social exclusion. The division of institutional work between private law and public law entails that public law is there to repair the harm caused by private, why let private law to create social harm if you can prevent it with a more fair contract law, more fair tort law? But even disregarding this question, the problem is that in real life, because this is what we're talking about, we're not talking about conceptual framework, we're talking about what kind of private law we should have in our societies. And in real life, these reparative public policies are completely contingent. They might never be implemented. And as I already mentioned, they are unstable, they change from government to government. But even when they're implemented, they arrive late, always, because they affect vulnerable people. And vulnerable groups cannot wait. Once you are in social welfare, once your son is forced to leave school, whatever aid you can give him would not get him back on track as it was before private law excluded. So it's much better to have private law that does not generate as much exclusion and subordination. Also, the efficacy of redistributive policies depends on the alignment of the different branches of public and private law with the distributive goals. It is naive to think that the public policy can succeed without considering how is private law. Suppose you give Achilles, you give him a subsidy because of his poverty. Then Achilles goes to the market to buy goods and services. And since private law allows the imposition of any terms, then most of the subsidy ends up at the hands of the wealthy people who impose unfair terms or contractual terms. There's no way that public law can make the job alone. It has to be, in a way, has to work side by side with private law. So the argument that I'm defending is not that private law can undertake all the primitive tasks in a liberal society. It's not that private law is better than public law. The argument is very, in a sense, modest. It's not very ambitious because it says, look, private law is not irrelevant. We cannot get rid of private law saying, no, these are extremely just considerations. They do not belong to the private law policy we're discussing here when we draft the next civil code. You cannot do just because private law has important consequences and can cause irreparable harm that's very difficult to solve through public law distribution. So the most successful policy probably involves institutions or the design of public law policies and private law policies. And this is all I wanted to say about Forrest Gump. This is all I have to say about this. Thank you very much for your attention.
Thank you very much, Professor Papayannis. I think it has been a magnificent closing lecture, which leaves us with serious concerns about the content, scope, and real function of current private law. We will proceed, as in the previous conference, to open the space for debate with the questions that our sisters wish to ask directly to Professor Papayannis.
Thank you for this, Diego. As you might have suspected, as your name revealing, I have a few minor disagreements with you. Near the end of your talk, you characterized the Kantian view as treating public law as having existing to repair the harm caused by private. That is a misconception, but my comments can be understood as an attempt to exist to repair the harm caused by Hanoch Begun's misunderstanding of the Kantian view. Because what you've done following Begun is assimilate the Kantian view of private law to a version of libertarianism, a view with which it shares a few doctrinal similarities, which are in fact shared by pretty much all views of private law, and no conceptual or normative commitments. And so what I obviously I don't want to go through everything in detail, but the key to the Kantian view is that distributive justice does not exist, and public law does not exist to repair harm caused by private law. Instead, there is a way we can characterize private law in abstraction from the existence of public legal institutions, and we can therefore understand its transactional structure. But once we so understand it, it's not that it causes a problem that we need public law to repair. It is instead that it is conceptually incomplete and requires public law to repair. The respect in which it is conceptually incomplete is that there is no unilateral standpoint in it, as a result of which private law, by being purely bilateral, is therefore ultimately still, as Kant puts it, unilateral, and so inconsistent with everyone's freedom. But the point of the poverty argument, the distributive justice argument, the distribution of offices argument, all of these are incidents of the constitution of an unilateral standpoint. And although it is true that in a state of nature, Kant says there is no problem of poverty, because there's no problem of poverty because if there is scarcity, it's just scarcity. And although you misleadingly say, well, in a state of nature, Achilles could appropriate all of the apples. No, Achilles could not appropriate all of the apples, because appropriation is making something your own. Achilles could pick one apple after another, and as soon as he put it down, Hector could pick it up, and there would be no wrongdoing. And so that is not the problem. The problem is that once there is a right to exclude, there is a question of whether the person who has no access to something can share an unilateral will with others. And the key point is that at each stage of the Kantian analysis, this goes also for my examples of healthcare and labor law, the question to be answered is not what harm caused by private law is this repairing. That's not the question whatsoever. The question instead is, could it be consistent with a system of equal freedom under laws for a public authority to have this kind of power? And that power goes to a power to redistribute. It also goes to the power to remove things from the tort system, because it isn't that the Kantian view says everyone has private rights and then the state must not interfere with private rights. That isn't it at all. It's that private rights must be consistent with the freedom of everyone under law, and therefore a public authority must have certain kinds of powers to do so. And then you have to show that each of these powers is consistent. Those powers are not made consistent if they can only be exercised in a way that is humiliating to those who are the beneficiaries of. And so there is no, oh, well, distributive justice has its problem. Welfare systems in modern liberal democracy do not do a good job because they're fundamentally humiliating. And they are corrosive of the public culture on which they depend. But that thought can be expressed entirely in terms of the idea of creating a system in which people are all participants in the unilateral. Same point with respect to something like labor law. The point is that if there is a systematic inequality of bargaining power, that is a problem for the possibility of sharing an unilateral will. It's not that it is caused by private rights. But I also want to say something about your positive proposal, because the suggestion that somehow we could change private law in a way that it wouldn't be humiliating, or that it would somehow solve all of these problems and make us not need distributive institutions, is actually an idea that sounds like an alternative only because of the way in which it is radically underspecified. And if you think through what it requires, it would be far more humiliating as well as being completely unmanageable. Because what it would require instead is every shopkeeper to figure out, how much should I charge for this? Oh, should I have a price for wealthy people or a price for poor people? Oh, well, I could have different ones. Why? Well, because I should be able to do the hanach the gun thing, respond to need when there's need, but I shouldn't need to respond to need. I should be able to just be in it for myself when there isn't need. And so when Diego and I go into the shopkeeper can charge us an arm and a leg, but then there are the other people who need to take care of this condescending way. And so the thing that you complain about in public social institutions, you instead in the gun picture insists on importing into the moral psychology of every human being and every shop. They should always think about the welfare of the person with whom they're dealing and think about the impact of their act on the welfare of the person of which they're dealing. And that is to say, they should be noblesse oblige in the private case. And that is even more corrosive, the social basis of self-respect. So too, the person who thinks, oh, well, I mean, there will be some people, oh, great, I'm opportunistic. I get the discount. I now get a senior's discount. That is kind of totally perverse. I should be the last person in the world to get a senior's discount, but it's not a bad idea to have it just tied to age. Why? Because then it's not connected in that way. And so we prevent this kind of problem. But let's put it in private law. Let's tell the private actor to do this the right way. And so how much you bargain with me? Oh, you should bargain with me based on your assessment of who I am. And this seems to me that I can say, hey, all of the other seniors, they're old. That's their fault that they're old. But me, I'm different. I'm just old because of the earth revolving around the sun. So that's not my fault. I'm special. I'm give this. But the point is, if there is a problem about stigma, then moving everything into private law, the problem is you're trying to solve the exact same problem. You're trying to solve the problem of people having unmet needs. And you're trying to solve it not by having an idea of equal citizenship, but instead by an idea of private parties all considering every possible reason. The gun, I hope you don't follow the gun in trying to take all of this from Raz's theory. But the gun says, oh, this is like Raz's theory of reasons, and what you should do is be responsive to the real reasons, and then we have these intermediate things that are responsive to the reasons. But once you put everything into private law, all that you've done is eliminated Raz's theory of law, as well as Kant's theory of law, because you've eliminated all law, because you basically just said everyone should consider every situation on all of its particulars, be nice to everyone else. And as Kant says, it is impossible to find such a situation. But just to sum up, basic point is the Kantian theory is a theory of why it is that a public authority has certain powers. It is not a theory that says all of those powers are solving problems of the public. All of those powers are solving the public problem of how it is that everyone can be members of a public standard. And that, therefore, can't be tied to sorry for going this way. But just imagine how long.
Thank you, Arthur. Thank you. I respect the disagreements, of course. There's a lot to say, but I will focus on some general lines. First, I never construct the orthodox private law supporters are libertarians. Though I try to be very clear that you are not libertarians because you believe that the distributive has a place, but I think that it's not the correct place. I mean, it's exclusively linked to public law.
The libertarian concept. You don't have.
You don't have libertarian conception of private law, only in private law, but libertarian conception only means that whatever there is in the world is brought by someone with his effort, so distributive justice has no place. This is what defines a libertarian.
Yeah, that's it.
No, of course. That's why I agree that you're not libertarians. You're just mistaken. Not libertarians, mistaken for different reasons. No, you think that distributive justice is just a matter of public law, disregarding the potential of private law to contribute, and disregarding the dangers of private law trying to be neutral. There's no neutrality here. Private law can play in one team or the other. There's no neutrality. This is the first thing. The second, this is the paper I present. This is a very brief paper for the conference, but it's based on some book chapter that I'm working on that is 50 pages, and I explain all the omnilateral will. I explain everything. So, but I don't see the relevant. It's true. Public law is not just there to solve the problems of private law, but it's the part in which I'm interested in. There is no private law actually without public law in your reconstruction. I understand that completely. Private rights are completely undetermined. You say, okay, I have a right to my body. What does it mean exactly? It has to be determined. It has to be determined through public law, authorities, judgments that have to be always faithful to one way of analyzing the relationship between the parties. And you cannot go beyond that. I understand all that. But the part I was intended to focus on is the part in which distributed justice redistribution enters into play. And why redistribution is justified in that framework? Because private law might have terrible effects, leaving some people in a subordination. In that respect, I don't think I'm mistaken in the reconstruction. Yes, I think I'm not. Second, you say that my description of the state of nature is misleading or tricky in a way, but if you don't like the Achilles appropriate, I didn't say appropriating all the apples in the tree. I say takes all the apples in the tree. Take is a fact, it's not normative. Achilles is not claiming the state of nature, couldn't claim this is mine because there is no property. But if you don't like that example, because Achilles will have to take one apple at a time, suppose Achilles one night takes 2 apples, hides them, and burns the rest of the tree. So Hector wakes up and says, where is the tree? Where am I going to eat? Nothing, you're going to starve. I had 2 apples, once you die, I will eat 2 apples, and then I will die. Is that morally permissible in the state of nature? I don't think it is. I think it is respectful to the fact that there is another person that deserves some, well, respectively self-respect, of course. This is the point, that Achilles cannot do whatever he wants as long as he doesn't touch Hector. His duties, his moral duties go beyond that, way beyond that. Touching him is a starting point. Do not touch me with I'm consent, okay? Granted, but it's the only thing you owe me. No, you owe me much more things. For example, not determining my death just for fun. Not manipulating the context so I will die just for fun. Who can defend? I don't think Kant would defend such a view of the state of nature. He would say, this is incompatible with taking people seriously as persons with worth, intrinsic value, and not just as things. And regarding the possible proposal, I don't think private law would be humiliating. And so 2 things that you say are related. I think of crafting rules of private law in the legislative stage that do not require one-to-one consideration. Is he old enough for me to grant him a special prize? No. You have a rule. And the rule is that if you are above 65, you get that discount. For example, think of a mandatory warranty. in consumers law. In Spain, in Europe, I think it is. I think it is in Europe, but at least in Spain, for a mobile, you have 3 years warranty. Mandatory, 3 years. A mobile now, how long does it last? 4 years, 5 years? It covers almost the whole term of the usability of the object. This has redistributive effects, a lot. And I have another paper in which I show that at the beginning, most businessmen and enterprises say, no, this kind of warranties, mandatory warranties, are bad for consumers because the price will go high. These are all excuses. But they didn't want just to pay to replace the defective units, etc. But after some time, they start appreciating the benefits of warranty, mandatory warranty, because it was an efficient source of information. People come with the mobiles, you can see how they fail, why they fail, you can repair them, you can improve your product, make it more competitive in the market. So it is efficient, and it also has a very strong redistributive effect, because wealthy people, when after 2 years and a half suffer some problem with the mobile, they buy another one. The people that most claims file to get the warranty are the poor people. So prices do not increase as much as if you buy a private insurance. And this is redistributive because we all pay the same prices because of market price, but we not all benefit the same from warranty. It's rule. Poor people benefit more than rich people. This is a redistributive effect. Suppose the legislator had this effect in mind. Will he be doing something completely misleading, distorting private law? Not at all. There is a clear rule. If you sell mobiles, you have to do that. There's no judgment about whether your customer is poor or rich. There is no place for that kind of considerations in the proposal I made. I'm just saying that private law rules can have distributive effects, can be used to get distributive effects, and of course, some private law rules can have distributive effects that will destroy the equality that the parties deserve in private interactions. Of course. If you impose some mandatory terms according to which I'm almost your slave in terms of I have to make sure that you are always happy, that you are always well, that your children are well. But this is completely absurd. But I'm not talking about this kind of proposal. There is a limit, of course, and it's difficult to draw the line. But the difficulties in drawing the line doesn't mean that you should disregard the distributive effects, consider that do not belong within the private law discourse. Okay. And finally, you said that I'm moving everything to private law. Not everything to private law. Just I'm getting private law into the game. This is the only thing I'm trying to do. Thank you.
I'll try not to monopolize. But consumer protection, we've actually talked about before, and there's nothing inconsistent in it with the content picture. But my worry about framing it in terms of distributive justice, and this is a general worry about trying to say, oh, well, we'll get rid of this problem. There are two difficult. The first is, it only helps if your phone breaks down. That is, private law only interacts at the level of some kind of transaction. And if you're trying to deal with widespread, genuine problems of distributive justice, such as the wide gap in most liberal democracies now between the top 1% and especially the bottom, say 20% in income and wealth, the fact that if somebody's phone breaks, you're transferring a little bit of money from the 1% to that bottom 25%, that looks pretty incremental. But the other problem, and so you need to wait for a transaction because it's only if the phone breaks, or it's only if this happens, or if it's only if that happens. But the other problem is that the problems that you identify with what you mischaracterized as the distributive justice view apply here too. First, you can put it in through legislation, yeah, and then there's a new government and they change the legislation. No more phone warranties. You have this picture where it's somehow subordinating for the way your life goes to depend on the political process. And then you say, oh, well, the political process should produce this output. Your life still depends on whether the political process produces the relevant output in question. Second, it produces the output. So now you have the poor person has this saving of a couple €100 because they have a warranty on their phone and they go to the shop. And now the shopkeeper charges them unjust terms on the thing that they buy, which was the other thing you complained about. It seems that they can still do that. They can still be overcharged. And so it seems to me that all saying, oh, well, of course, I know your response, oh, we'll have a rule for that transaction too. But again, having consumer protection law, that's completely consistent with the content picture. Because the content picture is a picture that explains how it is that it can be acceptable for how your life goes to depend on decisions of public officials acting in a public capacity, even though it is not acceptable for you to be subject to the choice of a private person. That's the whole point of the content picture. The content picture does not start with a picture of private law and then say, what do we need to add to it? It starts with the question, how is it that positive law, which is positive in the sense of being chosen, could have gone differently? Different government, different judge deciding your case, different members of the jury. How is it that that can still be binding? And the answer is, if it is public in the right sense. But that means that you can put in consumer protection law, including at the other end. But you can't free it from that kind of contingency. If your worry is about the contingency of a different government making a different law, telling the government, oh, make a law about private interactions, that's not a solution to the problem that worries you. And it doesn't make the problem go away of some people depending on other people's private choice. Only a robust public sphere, which has the powers of the content state, which include discretionary powers and include the power of voters to remove a government, even when the government is doing a good job. One instead say, no, well, what you should really do is look at what the needs are, and then here's advice to the ideal legislator. That's not what philosophy does. I'll start.
Thank you. I think that the three things I want to make clear about, because you say a lot of things, and it's very difficult to.
No, I say only one.
Different ways. I think if I got you right, one accusation is private law can have only modest results in the distributive justice goal. But I'm giving one example. The redistributive effects are all over the place. When you add warranty, standards of care that can be higher or lower depending on the kind of collectives involved in the kind of interactions. Information duties. For example, in Europe, producers of financial products have the duty not only to inform, to advise, and to judge, and they're liable if they make them liable if they make a wrong judgment about the kind of laws that you can take, considering your situation. So the person has a duty that is really demanding. He has to know you well, your personality, whether you have children or not, what age are they, etc., etc., etc. All this is very important because it transfers two things. Since the other party has the duty to provide the information, this is getting information for free. If not for that duty, I would have to pay an advice. So tell me about which product should I buy, financial product. You have to pay an advisor. So someone is spending money to make sure that I get information and I'm getting it for free. You can say, okay, let's rule out that. Then it's my money that has to be spent in order for you to make business. So there's no neutrality. And there is no modesty in the results once you consider the aggregate of billions of consumers every day taking or benefiting from information duties, warranties, standard of care, and also liabilities. Strict liability, law and economics taught us, have the same incentives in terms of taking precautions. If I'm strictly liable, we take the same precautions. I will do something else like investing in research and development to reduce risk. I will do more things, but in terms of precautions, you will be safe of taking your own precautions to prevent my harm. So it's not money out of your pocket, it's money out of my pocket. But even if the risk is materialized, then some more money out of my pocket will go to your pocket. So this is all redistributive. It's impossible to prevent someone from benefiting or not from these rules. Once you consider all the rules, all these effects, and the billions of people that have interactions every day, I don't think that the results are modest. And I don't think that the preventive effects are modest. When strict liability was introduced, it was introduced because there were a lot of lawful risks that start hurting, for example, workers. They say, okay, we have to do something about this. It's unfair that we're making a lot of money and the people suffering from lawful risks, where I will say completely legitimate activities that should not be stopped. Well, the thing is that the burdens and benefits of the activity are not well distributed. So the best explanation of strict liability, at least in continental systems, has a distributive root. We were seeing that there was a lot of working men suffering the consequences of our capitalist system. You say, no, stop. We should make some transferences, not through the public law, through public law, through private law. Why not through public law? Well, public law has its own problems. Some of them I commented here. And here I'm linking with the second, that is the inefficacy. I thought, they say, okay, private law might be inefficacious. Private law can be inefficacious, is said? Inefficacy? Ineffective. Thank you. Can be ineffective. And also public law. I impose a mandatory warranty, so you put higher prices. I impose you tax, and you pass it on prices. The effect is the same, but it is contingent. And this plays both for private law and for public law. It is contingent. That depends on the slope of the demand, whether it's elastic or inelastic demand, and also on the offer. There are many considerations that say, look, you cannot say in advance that private law is going to be ineffective and public law is going to be effective. It's contingent, depends on empirical studies. So we should take into account all the effects of private law and public law and try to get the best combination. Yeah. And finally, the change in legislation, the idea that, okay, welfare programs change from government to government, this is unstable. Do you want the same for private law? To be, no, private law tend to be more stable. Actually, tell me, in your country, in the United States, or in any country, how many new policies you know to solve the problem of poverty? You have several policies for each government. They assess, reassess, they go back, they reinstore an old policy. It's a mess. It's a mess. And people cannot depend on that mess. Instead, in private law, all the changes have endured, this one, have lasted. When strict liability was installed, never went back. When information duties or consumer law tried to get better distributive results, it stayed. Because governments know they cannot play with private law in the same way that they play with public law, because private law regulates our everyday interactions. So you cannot change the rules of the game in the middle of the game all the time. So there is, I think, a political constraint, at least some legal conscience about, okay, we can play with public law, change our policies when they are shown to be ineffective, but you cannot do the same with private law. And I think this is a historical fact. You can check it and show me, look, in this country, yes, but in most countries, what happens when you introduce a rule that is fair, it stays. At least this is my view. But we continue, sure.
Yes.
So waiting here. I'm very, very sympathetic, but I want to suggest maybe you want to go along a certain kind of line. It's very difficult to figure out the best word here. Partly it seems like localized distributive justice, or maybe with respect to tort, the core thing is the distribution of the right to the integrity of one's person, although some of the things you're talking about go beyond that. It isn't sort of society-wide distributive justice that is really at play here. Another thought of just where to start from is there are things in private law and its Toronto content interpretation that lead people to associate it with libertarianism, though there are also, as well, recognized differences. But in some ways, for your purposes, it might be useful to start with libertarianism, and then I have a thought of how it might develop. Because one thing about libertarianism in private law, there aren't many people articulating it these days, but it has been articulated in the United States. Nozick has one chapter in Anarchy, State, and Utopia, which is quite brilliant, and Epstein has written enough that there's a clear view. And the way libertarianism goes is it prefers property and contract to tort whenever possible. It wants tort to shrink to the domain of interactions between strangers who don't have any kind of pre-existing contractual, that's why they're strangers, there was a pre-existing contractual relation. There isn't some kind of property relation. If you have a property relation or a contractual relation, then tort should cede the field to property or contract. And that has distributive effects in the accumulation of transactions over time, because in a market economy, just think of the way a contract works, your bargaining power depends on what the resources you have, and property is a fundamental kind of resource. So if you favor property and contract over tort, particularly over time, you favor a world in which the rights of people who have more stuff, simply they come to have better rights. And the contrary view, and it really is a piece of American political history, partly because, or legal history, partly because the United States has always had a weak welfare state, and as a result, it has private law doing things that private law doesn't really do in other countries, from what I can tell. But to take one example is to take product liability law and focus on Henningsen, because Henningsen is the case that says there can be no, you really can't disclaim, it leaves a little opening, but it's very hard to get through the warranty, implied warranty of merchantability with respect to accidents that inflict physical harm. And you just can't disclaim it. And it's responding to a world in which manufacturers had responded to Buick v. McPherson by standard form contracts of adhesion that restricted the rights of purchasers of automobiles to, if you have an accident and there's a defective part, just ship the part back to us and re-examine it and agree with you it's defective, we'll replace it. And that's how contract bargaining works in a mass economy. There's literature on that after law, from the race to the bottom. Strict liability just stops the race to the bottom, and it gives a more powerful right to product safety to a consumer. And what it does, but libertarians don't like that because it expands tort at the expense of contract. And it will have a distributive effect, or have an effect of making the tort right more effective. And the same thing as you touched on workers' compensation, has been widely understood in American law, I think generally correct, but not always correct, that strict enterprise liability, of which workers' compensation is and primary instantiation, is more protective of the safety of workers and consumers than fault liability. And it's more protective because it insists that the institution or activity responsible for imposing the risk bear it and disperse it, and that protects the participants in the enterprise, particularly the more exposure to harm, the more protection you get from it. And that very much migrated in instrumental dimension, so there was a powerful component of it in the last 50 years. It's probably been Calabrese, but as argued repeatedly, it has a non-instrumental thing. And I think it's consistent with your view, it has a distributive effect. And a third one where it's an example, it's not entirely clear how you adjust private law for it, but hot example in the United States at the moment is damages. And damages are a concern of yours because of the way they work with poor person and rich person in auto accident. Well, that's a general problem in damages, and it's notable that sort of statutory schemes of enterprise liability tend to restrict damages so that they require people who are richer to take out private insurance against it. It's more difficult, of course, to do anything like that, but it is consistent with the logic of what you want to restructure damages in that way. And the particular one that is a hot topic in the United States at the moment is the way in which the use of standard damage tables reproduces race and gender injustice, because income distribution in the United States, wage and property, it reproduces historic race and gender injustice, so that if you take simply tables, what you do is when you award damages and you're attempting to follow the purely private law norm of putting people in as good a position as they would have been had the accident not happened, you will reproduce wage and gender injustice going forward. And that seems to me to be a case that does pose a problem for a view like Arthur's, because it's a case where there's more going on in the damage table than just the interaction between the parties. That is the background, basic structure of society, and injustices in it. Whichever way you go on this, you're taking a position on the relation of background justice to foreground justice. And some adjustment of those rules seems to be the appropriate response for distributive justice and gender and racial justice reasons. And I think that is the place that Arthur might disagree. Well, I guess disagree. That where the view, the Toronto Kantian view of tort is strictly about the interaction between the parties. One doesn't describe what's going on. It's background justice affecting the determination of the damages owed, and where you really have to conceptualize it more systematically in order to do justice, and what you're doing is some kind of distributive justice and some kind of justice that rectifies past systemic injustice.
Okay, thank you, Greg. Also, lot of things. We'll focus on 5 or 4.
Yes, sorry.
No, about the libertarians. In the first draft of the book I'm writing, I had a chapter on the libertarians, but then I got tired. I got tired discussing with people that are so obtuse. I mean, I used to respect them a lot, but lately I cannot do it. I'm sorry. But I love reading Nosy. It's a fantastic mind. And the book is enjoyable, as opposed to reading Rawls that is not always enjoyable, but he's right.
Right has a lot of virtue.
Yeah. But about the libertarians, I wonder in which sense you say that according to them, property and contracts is preferable to torts, because in just said like that, I agree. Contract solution, it is better. The problem with libertarians is that you can bargain without constraints. But within a constraint, in my own view, property, you will have some rights. I have 3 years grant. Okay, what do you give me in order to give up that? I agree on that. And then I take my chances, not until I'm liberal. I mean, this is the liberal proposal. So, well, maybe I will need to understand a little better what you mean by.
I think it's Epstein is where you find that. Look at Epstein on product liability law or Epstein on landowner duties to entrance onto property, you see the structure of the position.
No, I understand.
Epstein to like.
No, I understand libertarian point of view, and I think is that's sensitive. The problem is the framework in which they make that suggestion. What would you say in general? Is better people to agree and trade or to repair? Well, it's much better to agree and trade. In general.
Right.
Within a framework.
But then you could say the Henningsen framework is regulated contract, not not freedom of contract as libertarians.
No, because Henningsen involves something that cannot be traded, personal security. It's like selling kidneys. Well, you're not allowed to sell kidneys. I favor contracts, but not any contract independently of what is the object of the contract. About enterprise liability, yes, I agree, completely agree on that. I'm not going to. We discussed in the workshop your book 2 months ago about enterprise liability a lot. We have some minor differences, but as I told you, in general, I'm sympathetic, and it's also a good example. In continental systems, what happened is not the creation of such a thing as enterprise liability in general, we say. It is a strict liability. And there's some conditions, but the kind of reason is more or less the same. We also know that when you have strict liability, or it is unwise to impose strict liability if the law of the big numbers is not there, because you cannot buy insurance, and I think we agree. About damages, this is very important, I think also. Our friend Sahi Karen-Pat has done a lot of work there and suggesting, and some of his suggestions are, I think, feasible. Some of them are radical, as he puts it. Said, okay, this is a radical suggestion. Everyone can be compensated by the average loss, or well, this is more difficult to do. But I understand that in damages, there is some room to make distributive policy. I will give this example. In my university, I own a workersman car, Seat Arona, very simple car, 20,000 euros car. That's it. My colleague in the commercial law department owns a Tesla, and we park next to each other. And I'm always the same. When I'm parking, I'm taking extra care, because if I touch his car, my insurance will charge me a lot next year, because representatives. So whose fault is? If you have a car like mine, the harm, the injury wouldn't be that severe. But you're charging it on me. Who should be responsible? Maybe if you are going with something really, really expensive, you have a Rolls Royce, well, you have to take your own losses, buy your own insurance, as you suggest. I don't see there any conflict between interpersonal respect. Respect me. The fact that you bring this expensive car brings a risk on me, a financial risk. If you have a less expensive car or your own insurance, we will be fine. We will relate to each other in a respectful way. But now you're saying, look, my expensive car, don't touch it. Now I have to restrict my freedom to protect your expensive car. Why is that so? So in remedies, I think that we can take, including limitations of what compensation you get in certain kind of injuries, I think we can make some policy. But I'm not suggesting that. This is not one of my proposals, but I think that Sahi there has a point, strong. Regarding damages tables, this is here in Colombia also a very important problem. And in my view, tables are important when you have irreparable harm, which by definition is not only difficult to quantify, it's just sometimes arbitrary. The quantification is arbitrary. There is no restitutio ad integrum here. It is not something that we can be restored. So, which is the room for public policy there? Well, there is a room, but I wouldn't abuse of damages tables. I wouldn't abuse. I will try to get which kind of compensation is reasonable, as we discussed in your own presentation yesterday. What is the purpose of damages in those kind of cases? Give you means to pursue a new life. Well, then the amount of damages should reflect the severity of the harm, but should also guarantee the continuity of the system, that the system does not break down because of huge amounts of money, and also should be significant in the sense of giving you enough means to reconduct your life to new horizons. These are three constraints, I think. So the limits of public policy should be within that framework. It's not like we can take these tables because we see that 80% of the people are people, very poor people that deserve more. Now we can take the opportunity to give them what they deserve. No, I'm not in favor of that. This should be done through public law. I'm not against using public law. Public law takes probably the most important part of the redistribution problem, but cannot do it alone and cannot do it if private law collaborate. This is the idea. Private law can be a help or a problem. There is nothing in between. It cannot be neutral. This is the point. Can be a help or a problem. On which side are you arguing? That's the question. And finally, I think also you are completely right about the background justice. This is when I was writing my dissertation, one thing that I read from your papers, from your early papers. I saw it clear, and this was the key for, I didn't know what to defend. I had a lot of intuitions that everyone that starts with the dissertation, and then I start thinking about how private law constitutes the rights that we have and the background justice. But in terms of, in analytical terms, I would say, okay, you have property rights. I have a property right on this computer. Okay, what are the limits? How much is protected? Because it's fine, I can do whatever, I can exclude you. Okay, fine. What happens if you break it? It's the same if you break it accidentally, if you break it on purpose. Because this seems to vary on the context. I have physical integrity, but if we go, I have a right to physical integrity. What does it mean? I can break your knee in a football match if I'm not doing it on purpose. This is the real physical integrity, right? Physical integrity you have. So tort law is integrated in property law, and everything is together. It's interdependent. You cannot define or tell me what property right I have if you don't consider contract law, tort law, etc. And if property law is a matter of background justice and the two principles of justice apply, then applies also to tort law, because tort law is in part constitutive of the content of the private law. So completely agree. Thank you.
Okay, thank you, Diego, for your presentation and the paper. I think I mentioned before we discussed some aspects. I really enjoyed it. I just want to something different, but actually your answer was about the stability of private law. And I'm thinking, what this could be a real problem, or at least this means that you will need something else. And so let me explain. So if the private laws are not distributive, you have a real problem. It's need, of course, consensus for private law reform to happen. And I think there is enough evidence that private law reform takes centers, right? So this could be a problem. And this makes me think, well, maybe what you're pointing out is the room that judges have to interpret private, or the room that private law gives judges to interpret private law to be sensitive to distributive concerns when they apply private. And so this probably could be that you have to have an understanding and a theory, or which kind of judges are you talking about, and how you justify this role of judges, because in a way I think maybe this could collapse into that the issue here is that judges shouldn't be doing corrective justice in these cases, but much more than that. And I'm wondering whether actually it's all about that. Yeah, okay, thank you.
Thank you, Wada. Thank you. I think you're pointing out one of the sources of the big disagreement that we might have with Arthur and the Canadian in general. But yeah, because it's your school. As part of common law, they think that private law is about litigation. And in my view, it's a completely different thing. Private law starts in legislation. So judges should apply corrective justice, should not make any distributive justice. They just apply the rule according to which if you break, if you harm the neighbor's Tesla, you pay less. They apply the rule. They don't make it in consideration of distributive justice saying, is this really fair considering that Diego now has more money? Well, no, it's not. It's not their role to make these judgments, except in two cases. Except in two cases. So the role of the judge, I'm sympathetic. This is why I like what Arthur writes and what Weinberg writes. I think that they gave a more or less precise, quite precise description about what litigation in private law is about. It's about asserting the rights the parties, and it's about rectifying, it's about, okay, right, that's all right. But the rights of the party are distributive in nature. This is the thesis that they will resist to the end. And second, in which two cases I think that there is room for the judge to make distributive judgments? There are two cases. One, when the legislature says in our civil law, civil codes, there are two provisions that are clear, that clearly require to make distributive considerations. One is ad hoc mitigation. In certain circumstances, you can, for equity reasons, you can reduce the amount of damages. The typical example is two young boys, but legally liable, enter into a stable where there are two horses. They are playing with the kerosene lamp. They want to see the horses, and the kerosene lamp falls. There is a big fire, and the horses are €500 million each. So considering the kind of negligence, considering that they are poor, that they want to be adults, and they will start 20 floors down their adult life, you can say, I consider that they are insured, because no one in his senses has $500 million in 4 legs without insurance. Considering all that, the judge can reduce it to €10,000, and that's it. And the rest, which will be the difference? The owner will be paid by the insurance, but the insurance cannot recover from the. And this is a distributive justice side, because it's up to the judge to make that decision to reduce and how much to reduce, whether to reduce or not. And it's consistent with corrective justice in a sense, because all the provisions, at least 17 or 18 countries that have this same ad hoc litigation provision in civil codes. And in all cases, intentional harm is excluded, and even severe negligence is excluded from ad hoc litigation. So there is a framework in which you can make distributive justice considerations. And the other provision is responsibility for equity reasons. This is for involuntary harms. Suppose someone very, very rich harms who lost his mind, momentarily loses his mind, and harms someone who is really, really poor. The fact that he's lost his mind is not, in principle, in civil law countries, there is no liability for involuntary. Voluntary, I mean, without liberty, without consciousness, in a sense. Well, that does not prevent the judge, if he considers so, to impose liability, which is the most strict kind of liability there is. You pay because you have money, not because you have done, not because you violated rights. Because since there is no action, no agency, there is no violation of that. It's an unfortunate event, but you pay because you have money, and the other one is poor. This is, we have, okay, well, sorry. Yeah, yeah. No, the second case, I say the second case, just, I don't explain it, I would say, which is legal gaps, inconsistency of rules and indetermination, negligence, duty of care, which is the duty of care, or the standard of care. This kind of determinations can be, in these cases, can be placed in which distributive justice and religion can enter also in adjudication, but it's very limited. Yes. That's the thing, but in principle, limited. The judge, I have the role of the judge making corrective justice. But yeah, it's difficult to give a full reply when Alex is pressing me.
Okay, so thank you, Diego, for an interesting topic, and I'm eager to read the paper. I sympathize with the cause. So, but let me be a little bit of a devil's advocate. So my main question is how we can do it, because I agree that distributed justice should be something to be taken care of private law. I don't think private law should dismiss the distributed kind of justice. But the question, my question is how exactly we do it. Part you answered this like in the last couple of minutes. This, for example, this mechanism, this rule of reduction of damages is it's very exceptional actually. It's like only a few countries that have that rule. Although it's on the principles, so it's European laws, so it's interesting. The most of these rules say that this is an exceptional case, right? So, and it's also very controversial, like what's the foundation of that rule? Like some people mention like insolvency problems, for example, like it makes sense. I mean, if the person, obviously to put a judgment on a person who is indebted, completely indebted, it would make sense. You make him pay like $1 million, and he can pay. I mean, it's really good. So it makes sense to make this reduction. I don't know if that's a risk of distributed justice. Some of these rules also mention like there's disproportionate between the harm done and the kind of reprehensible behavior. Like this is the relationship, not necessarily between the condition of the parties. So I'm wondering, like, if we have in private law tools, good tools or better tools than private law to deal with these problems. Like I was thinking in when you mentioned like the hurricane cases and disasters, natural disasters. We have in Chile the tsunami cases in 2010, in which plaintiffs sued the state because the state failed to warn people to when to safe places. They didn't issue the tsunami alert, so many people died. Actually. And the cases are very complicated, and they start questioning, for example, causation, mostly causation, right? So that's a good example of like private law. Is that a better tool to deal with this problem? Because mostly causation, we know that this is a concept very slippery and difficult. So causation probably won't be the better way to deal. So my main concern is like, do we have the tools, or do we need some new tools like this kind of rules of reduction, or something else?
We accumulate them?
Yeah.
Okay.
Waiting.
I hope to remember that later. Sorry.
Thank you, Diego, for the presentation. My question is about the tools of private law to confront this challenge of public or social challenge. For instance, equality, poverty, and distribution. What do you think about the introduction in private law of positive duties or affirmative actions? Private law. Which one and when in any area in particular? Thank you.
Thank you, Professor, for sharing your ideas. You have mentioned in another paper, the distributive private law finds meaning only in the substance of an available framework of interaction. Talking about that kind of framework of interaction, my question is about the nature of the rules governing framework of interaction. Should those rules be public standards or private standards be integrated? Or by the very fact of regulating this kind of framework, should those rules be considered as public standards? I don't know if it's related to this matter, or have in mind those regulatory sandbox. Regulatory sandbox. Kind of interactive sandbox regulatorios. Sandbox. Those are kind of those kind of sandbox. It's in a space in a real life for testing new products, new innovations, new approaches, without having in mind regulatory or any kind of public roles. Those spaces, those frameworks are temporary.
It's pretty sure. Don't you think that selfishness is an element essential or definitive in private law? Any grade cannot eliminate selfishness. You can reduce it. You have to have a power of dispute others to can talk about private. So when it's private, there is not a possibility to dispute others.
Thank you. Okay, I will try to do it as fast as I can. Alberto, in respect, I think we have different interpretation about dog litigation, because I don't see all these requirements of intentional conduct or misbehavior and proportionality, all that, as the rationale to decide about litigation. I see it as a constraint. Once you have judged that the misconduct is serious enough, there is no room for about litigation. Once you have verified that, well, this is so routinary negligent and mislap, then you could apply. You could. It's very exceptional, this rule. And I stick to the traditional interpretation, according to which this is should be applied very in exceptional cases. And most of the legislation say, in exceptional cases, the judge might, this is the European principles of law, in exceptional cases, and you should take seriously what the legislation says, in exceptional cases, not on the regular basis, you're just a Robin Hood here, like get a dog mitigation or whatever. Regarding the other cases, I'm not in favor of playing with the doctrine, like causation to make it other or whatever. Calabresi did. In the 70s, he had a paper saying, okay, we can use different concepts of causation depending on what we want to reach. The sine qua non is much better to make more people liable than so they don't get that. It's very difficult. In fact, criminal causation is one of the more complex, but at a certain point, I settled with Hart Honoré, Richard Wright version, test nest. This is the conception I'm going to use, and this is the conception I want judges to use. They will solve most of the problems, and they have only a factual view of causation, and then all the other considerations go to the attribution, responsibility, liability problems. So what I'm suggesting, for example, now there is a new rule. This is, I read it on the papers, I haven't read the actual rule, but it's a good example. I don't know how to say in English, this rule, norm or this new law about when derecho al olvido, how is it, the right to forget, right to be forgotten, oncological right to be forgotten. But this is a huge advance. People couldn't get a mortgage because public records said he was an oncological patient. Now he's cured. Now he's willing to pursue his life. Now let's buy a house, go to no, the mortgage is reduced. This has huge distributive effects for this particular group. Cannot be regarded like, no, this is not important. This kind of laws are not in a way incompatible with corrective justice. I'm not, you can have different views of corrective justice. According to one view, I'm entitled to know what kind of partner are you in our business. So I have to know whether you're a risky partner or not. I'm going to give you a lot of money after all. According to another view, well, this is the kind of information that you cannot have. So even corrective justice, understood in one way, would be in favor of that. But when you consider the distributive effects, this is a second reason, distributive justice reason to support this kind of laws. So not always corrective justice and distributive justice go in opposite directions. Most of the time, the distributive justice effect is supported by corrective justice. Corrective justice. Esteban, about affirmative actions, can you say something similar about this case, this kind of laws? In general, I'm in favor. For example, you have to hire women until you're not allowed to hire more men until your staff is balanced, gender balanced. What kind of restriction is that? There is a case in Argentina, the Privado case, in which they argued, look, we sell ice cream, the cubes of ice cream weigh more than 20 kilos, women cannot lift that. So I said, I don't care. You just have to make the effort and put the women to do something else if it is true that they cannot do it, which is not proven, etc. So I completely in favor, and this kind of decisions, this was a court decision. I find it also, sorry, Supreme Court decision. I find it plausible and useful. Private standards. You should ask Anita. She has an old paper about how communities make standards of care or rules of negligence. I read it a long time ago, but
it's old. It's 21 years old.
I like it a lot, and I'm going to use it soon again. Of course, the rules of interaction are mostly public standards, mostly. But as I argues, it's impossible. It's impossible. It would be impossible for judges or legislators to legislate and to find the optimal rule of interaction for the diversity of communities we have. We have the doctors, we have the merchant people, we have a lot of communities with their own standards. It's much more efficient to pay attention of the standards that they customary have and to then assess them legally, because they might have unreasonable standards. But if they're reasonable, well, you save a lot of transaction cost. And not only, it would be impossible to have negligence law if you not rely in any degree to private standards. They become public after the decision. But up to that moment, they were private standards. I'm going to leave the sandbox question, then we can discuss it a little further. And finally, Alex, the selfishness. I don't think that private law entails selfishness, not also altruism as Esteban is too optimistic about the human nature. But I think that this is more the Rosean idea of disinterested, how you say that people that are not disinterested people, like, well, I don't mind whatever you do with your life. I'm not jealous about you. I don't envy you. I'm not concerned only about my affairs. And this is enough. But in any case, redistributive rules, private law, do not require of you any kind of character. They do not require you to be selfish or to be altruist or to be a socialist. No, there are rules. You have to obey them. They require you to be a good citizen and to play by the rules. By the rules because there are rules that apply. Once you follow the rules, if the legislature made all the calculations correct, the distributive justice desired outcome will emerge spontaneously. This is the maybe too idealized, but not as much as wine river idea of revenue.
Thank you very much.
Thank you. Thank you.